Do you take questions? We're going to take questions live.
Yes, we will be taking questions live at the end.
Perfect.
We're live right now.
Oh, sounds good.
We just haven't started yet. People are still joining. All right, well, let's go ahead and get started. Hello, everyone. Thank you so much for joining today's webinar. We're going to be talking about Medicare set-asides in workers' compensation and liability settlements today. We have a lot to cover, so I'm going to dive right in. I hope that for those of you that are still joining, that you can just jump right in with us. My name is Heather Schwartz Sanderson, and on behalf of Sanderson Firm, delighted to invite you to today's webinar. We have a special guest speaker today, and I will introduce him momentarily. First off, I want to go through some housekeeping items. First of all, at the end of this webinar, and I think a day or so after the webinar completes, you will receive a survey. It's going to ask you a few questions about today's webinar. I would greatly appreciate if you could fill that out and give us some feedback. Secondarily, we will be taking live Q&A, but we're going to hold those until the end of the presentation. You'll see in your Zoom function that there's a Q&A box. Feel free to type those in at any time, and we will take those questions at the end. You can type those in now. If for some reason we don't get to your question today, please feel free to email either myself or Sean. Our email addresses are on the screen. Lastly, if you'd like a copy of today's PowerPoint, I'm happy to share it with you, but I don't want to send it out en masse. So I'd appreciate if you'd like either a copy of today's presentation or a recording link, because I will be recording today's webinar. If you'd like to watch it again in the future or share it with a coworker, please email me and I will happily share the PowerPoint and the recording from today. So with that, let's get started. So I'm really excited that today we have a guest speaker, Sean Dean, Esquire. He is a friend, a colleague in the industry for a long time. I think very highly of his knowledge, and I thought he'd be a great speaker today because professional administration ties in with MSAs. And I know there's going to be some questions on that as well. And he's going to offer a little bit of his perspective, particularly with items that are going on right now. Sean and I just co-authored an article in CLM magazine on MSAs. So I'm happy to share a link to that article also after. So let me tell you a little bit about Sean. He is currently the General Counsel and Senior Vice President of Risk Management and Compliance at Amitros Corporation. Sanderson Firm is a partner with Amitros. They do a great job on professionally administering Medicare set-asides, and Sean will give you a quick blurb about that at the end of the presentation. But he's got over a decade of experience in Medicare secondary payer. He was previously Vice President of Medicare Compliance at ISO Claims Partners. He had practiced insurance and healthcare law before that. He's been heavily involved with industry associations. He's got his certified Medicare secondary payer professional license. He's actually a professor of law at the New England Law Boston and Massachusetts School of Law. I'm very proud of him on that because he's a busy full-time job, dad, and teaching full-time at law school. So I'm sure he never sleeps. Sean is a member of the Massachusetts Bar, and he's licensed in the state and federal courts in Massachusetts. And he's certainly got his law degree from Massachusetts School of Law. And he also has his master's as well. I didn't even know that, Sean, you had your master's as well. That's wonderful, from Cambridge College. So that's Sean. We're delighted to have him here today. He'll be jumping in at times. And I'm also going to introduce myself just briefly. I saw some new names registered on today's webinar, so I'm delighted about that. I've been a Medicare secondary payer attorney for about 15 years now. I have served various roles at pretty much all the large Medicare set-aside vendors in the space up until I decided it was the right time for me. After serving as Franco Signor's Chief Legal Officer for 6 years, after the acquisition by Verisk decided to start Sanderson Firm. Our approach is a boutique style approach to Medicare secondary payer compliance. We've got an innovative and legal spin on how we do things, and we're providing our clients some really great solutions, which we'll talk about at the end of the presentation. So thankful for you all being here today. Without further ado, we've got a lot to cover. Let's get started. So we're going to lay a little bit of a foundation before we dive into what's new and exciting on Medicare set-asides. I know there might be some people on today's webinar that might be new to Medicare secondary payer or new to Medicare set-asides. So let's talk about how we got here today, what they are and what they're meant to do. We're going to talk about workers' compensation Medicare set-asides. We're going to also talk about some developments on liability Medicare set-asides. We're going to talk about the hot update going on right now regarding non-submit or evidence-based Medicare set-asides. We are going to talk about this in the context of a reference guide update that just recently occurred in January, where CMS made an update or a new section on MSAs or evidence-based Medicare set-asides. And we're going to talk about that. I know you all want to hear about that. And then subsequent to that, we're going to talk about a webinar that CMS hosted on MSAs just last month, which told us a lot about both traditional submitted MSAs to CMS as well as evidence-based Medicare set-asides. We're going to do a quick blurb about Sanderson Firm at the end and let Sean briefly tell you about Amitros, and then we're going to take questions. So I already see people are populating questions, which I'm so glad to see. So thank you. Keep the questions coming. There's a lot to discuss. So what is a Medicare set-aside, right? It is a financial agreement between an injured individual and CMS. It certainly allocates a portion of the settlement that is designated for that injured worker's future medical care that would otherwise be covered by Medicare. It's a settlement tool, right? It allows a Medicare beneficiary to preserve their Medicare benefits, and it also allows employers or insurance carriers in the liability context to settle out the claim. And in certain instances, Medicare may review and approve a proposed MSA. Now, where is the legal basis for MSAs? And Sean, I know you and I have discussed this before, right? There actually is no terminology in the Medicare Secondary Payer Act referring to a Medicare set-aside. You won't find it. You won't also find the clause protection of Medicare's interest. What you will find in the Code of Federal Regulations that's associated with the Medicare Secondary Payer Act is addressing how Medicare's interests are to be protected in the instance where there is a lump sum settlement, right? So what the statute says is that to the extent there is a specific allocation for the future medical component out of the settlement, and that's what you're seeing on your screen here, 42 CFR 411.46D2 says that as so long as a certain portion of the settlement is allocated for future medical, doesn't say it has to be an approved MSA, by CMS, it just says an allocation, right? Then Medicare will only coordinate benefits for that future medical amount. They cannot coordinate benefits up to the whole settlement amount, which is going to lead you into the prior conversation that I was mentioning. We're going to talk a lot about non-submit MSAs and why they are still a viable way to settle your workers' compensation claims. So really, we saw Medicare set-asides become a permanent fixture in workers' compensation claims in 2001 when the Patel memo came out. But prior to that, we did see some early writings starting to talk about Medicare set-asides and their use in workers' compensation settlements. So again, I just mentioned the Patel memo. This was the first memo where CMS, the Centers for Medicare and Medicaid Services, introduced Medicare set-asides and noted that they were their preferred method of protecting Medicare's interest. And they established this review process now at Medicare where they would review proposed MSAs, and they became a standard fixture in workers' compensation claims. And here's a copy of the infamous Patel memo. So now we are going on, this is close to 21 years old, which is just wild.
And Heather, I meant to get it, but I might have the only signed copy of the Patel memo in existence, and I should have brought it to hold it up for your viewers. But something really quick I just want to add. You had some pretty important sources with respect to early writings around WCMSAs. I think it's important if you're a student of this stuff to go back and read those two articles vis-a-vis the Patel memo. It's almost the same exact writing that showed up in the Patel memo. And if you're a history buff of this stuff like Heather and I are, you'll see really where it came from and how that policy got solidified by folks doing this basically in the industry before CMS blessed it by way of policy. It's pretty interesting stuff.
It is, and that's really fascinating that you got to meet Mr. Patel and get a signed copy of the memo for us geeks, MSP, MSA geeks. That's great. That's a great, very interesting comment. Thank you, Sean. So let's talk about what the current thresholds are for CMS review, right? So currently, a claimant is a Medicare beneficiary and the settlement is greater than $25,000, or the claimant has a reasonable expectation of Medicare enrollment within 30 months of the settlement date, and the total settlement amount is greater than $250,000, Medicare will review an MSA. It is important to note that this is a voluntary procedure. Medicare mentions that numerous times throughout the WCMSA reference guide. It is not a mandatory review process. I've seen far too many settlements that make me want to cry because people are making their settlements at $24,999, thinking that if the settlement was actually $25,000, that it would be required to be submitted. I think that looks a little funky. And, you know, remember that $24,999 settlement is going to be reported to Medicare. So I think that just raises red flags. I think just be comfortable knowing that this process is voluntary. It's recommended, but voluntary. So when a proposed MSA is submitted to CMS, it goes to the Workers' Compensation Review Contractor, also known as the WCRC. And then they forward their recommendation along to the CMS regional office, who then makes the final determination. Just briefly want to cover the processes if you submit an MSA to CMS and you feel that it is incorrect. There are two methodologies for CMS review. The first being, and this process has existed for a long time, this is a standard re-review. This is when Medicare has made a mathematical error, such as pricing, or when there is documentation that was not submitted to CMS along with the original submission that predates CMS's determination. It can't be any medical records that post-date CMS's decision. In those cases, they will re-review an MSA. Where I think most are looking for, a re-review by CMS is actually the amended review process. And the amended review process is for circumstances where you've submitted an MSA to CMS, but medical circumstances have changed and you have not settled the claim yet, and you want to get a change in the MSA, either greater or lower. Now, this is only available, amended review, if your CMS determination is 1 year to 6 years old. So it can't be, within the first year, and it can't be beyond 6 years old. So I was just asked about this last week. Hey, I've got a 7-year-old CMS determination. Can I get Medicare to re-review it? No, unfortunately. And that's one of the limitations in the CMS review process. But you also have to allege that the projected care has changed so much that the submitter's new proposed amount would result in a 10% or $10,000 change, whichever is greater. And so these are the few options here. Right? So now that's workers' comp MSAs. So now if you work with liability claims, you're listening to this webinar, you're like, what is going on with LMSAs, right? You want to know. Well, unfortunately, we're still in this limbo, in this ambiguous area where there is no process or procedure for CMS to review proposed liability MSAs. About a decade ago, we saw Medicare starting to do a rulemaking on LMSAs, right? This was issued in 2012. It was then withdrawn in 2014. And then in 2020, we saw Medicare looking to potentially issue a proposed rule on LMSAs. And I'm going to talk about it here momentarily, but we're now seeing Medicare move on that rule again. But let me put a pin in that for the moment. I do want to show you the only memo or actual official, right, Sean? Because we can. I don't think I put the stall cup memo in here. I'm going to let you talk about that momentarily and what that says, because I think I didn't include that. But this is the only official CMS memo that CMS has put out on liability MSAs to date, and you can see it's 11 years old, and I don't even know if it's still technically policy because it's not on CMS's website, but it says you don't need an LMSA if the treating physician can certify that no future care is needed. And that's pretty much it. It doesn't tell you when you actually need one, but only tells you when you don't need one. Sean, I'd love for you to talk to everyone about the Stallcup memo, which came out like what, a year later. And even though it came out and it was written by a regional administrator of CMS, it wasn't like an official correspondence of CMS.
Yeah, to my recollection, you can check me on it. I think it came out before this one actually. It came out the same year, I think around in March or May, but in any event, yeah, it was, it's become affectionately known as the Stallcup memo, and it was issued by Sally Stallcup. I think it was the Dallas regional office.
That's right.
Who issued it. And it looked like CMS policy because it was on CMS, memo letterhead. And I think it was meant more to be educational in nature versus an official policy position taken by CMS. Obviously, it didn't make its way into the reference guide or any other sanctioned memoranda issued by CMS, but it clearly outlined and articulated a policy stance that CMS has indicated throughout the years at various industry conferences, in certain town halls. Certainly, I think you can glean that from this September 29th memo, but effectively it indicated instances where parties should either, quote, protect or consider CMS's interests. So it's another tell from CMS that they feel that their interests should be considered up against future medicals within a liability settlement. But it wasn't like this one you indicated, Heather, that was, official, telling folks when they effectively don't need to do an MSA, not when they need to take affirmative steps to do one. But I think that one has been referenced quite a bit in various articles, but it doesn't have the same weight necessarily as official CMS memoranda.
That's right, Sean. It was meant to be educational, but in fact, I think that the Stallcup memo actually told us more than what this memo did, because with the Stallcup memo, the main gist I got out of what Ms. Stallcup was trying to say was that to the extent that you're entering into a liability settlement with a Medicare beneficiary, and there is funding for future medical as part of that settlement, and you will be closing out that. Obviously, you're not paying for medical during the pendency of the claim, but if part of that lump sum settlement is intended for future medical expenses related to that injury, that there should be a protection of Medicare's interest via, a future medical allocation, a liability MSA. But again, not binding, because this is more of an educational handout. So I mentioned this just a moment ago, and this is the latest on what's going on with liability MSAs. We know for sure that, so I mentioned earlier that there was a proposed rule that's been kind of lingering like it was about to move since 2020. Well, now we know that Medicare has written their proposed rule. They have on LMSAs, or how to protect Medicare's interests in liability settlements. And actually, if you look at the description of the proposed rule, it's not here on the screen, but it also mentions that this proposed rule, because it's generically called MSP and future medicals, it could also impact workers' compensation claims. We're not sure yet, but it does also mention workers' compensation in there. So it'll be interesting to see if it impacts work comp as well. But nonetheless, Medicare has written their proposed rule, and it is now currently being reviewed at the Office of Information and Regulatory Affairs at the White House. And so the process now from here, if you're not familiar with how these rules work, right? So now the proposed rule is being reviewed at OIRA. If OIRA takes no objections, which I don't anticipate there would be any, this is something that Medicare has been trying to push off their desk for a decade, then it will move to a publication, right? So we'll be able to see what is Medicare proposing in this proposed rule for how we're supposed to protect Medicare's interests in future medical situations in both liability and work comp claims. And it may be liability focused, even though the description says workers' compensation. And at that point, we as an industry will have 60 days to comment on the proposed rule. And we can tell Medicare this, we think this is a good idea, we think this is a bad idea, it's all public. I'm sure we'll all be taking part in that. And then Medicare goes back they digest the comments, they have to then respond to all the comments out there when they issue their final rule. And once we have a final rule, which may not be this year, it could be next year or within the next year or two, that is when we will actually have a effective policy on LMSAs. But until we get there, we're just going to continue to monitor this, and we're still in that state of limbo on liability MSAs, kind of look into the Stalcup memo and the other memo referenced in the prior slide. Something else, if we're reading the tea leaves, so to speak, right? My firm just saw this notice, we blogged about it, I think it was last week, that Medicare has issued a sources sought notice. So this is the step before a request for proposal, that they're potentially going to be looking at a new contractor for the WCRC, the entity that reviews proposed MSAs at CMS and workers' compensation. And they're looking for entities out there with capacity. And it's noted in this sources sought notice that this contractor would have to review not only workers' compensation MSAs, but also other non-group health plan MSAs, which would mean liability MSAs. So I think CMS is gearing up. I mean, what do you think, Sean? I would love to know what your thoughts are. Having been in this space for a while and seeing what Medicare is coming out with now, what would you predict?
Yeah, I mean, I have to couch this with all of this is speculative on my part, but I think taken in conjunction with the totality of everything that you've been discussing, it's clear that CMS believes that their interests need to be protected when there are post-settlement medicals implicated in a liability settlement, just as there are under the WCMSA program. That to me seems clear that it's CMS's position, especially in light of the fact of where this potential rule that could be promulgated is in the administrative rulemaking process. I think another thing to point out too, and not to go off on a tangent, but just to talk about mechanically and administratively how Medicare effectuates coordination of benefits after a settlement. So kind of the side I'm on as a professional administrator, when an MSA is submitted, a work comp MSA is submitted and approved, there is a particular flag that gets noted in the Medicare beneficiary's common working file. And if you're not into Medicare billing, that's fine. All you need to know is if a bill goes through for which Medicare can pay through the processing of that bill, and the services are related to the underlying injuries that are otherwise covered by Medicare, Medicare has the ability to deny that payment in a work comp setting. What I think a lot of folks don't know too is going back to, I think it's around 2017, they instituted the same functionality with an LMSA code. That's there, they have the ability to do it. So I guess that's a long-winded way of saying that I think it's clear that they're moving in that direction. Now, the question for us on the sidelines here a little bit, and especially for you, Heather, with you and your firm helping folks deal with this, is what do you do between now in the interim and when you have something in black and white in writing? And I think that's kind of the more interesting question. It's easy for me to opine, but it's harder when you're in the throes of trying to settle a workers' compensation case. And I guess I'll hand it to you on answering that question, but my feelings on it are you have to take each case on a case-by-case basis. It's certainly fact and situationally specific as far as the outline, or as far as how you're going to address the issue of future medicals. And it also largely has to do with the risk tolerances of the parties and their philosophical interpretation or legal interpretation of how in the totality CMS's guidance could potentially affect them. If you believe that CMS is going to likely deny bills if you fail to include post-settlement medicals in an LMSA, then you probably should take steps to protect that beneficiary. I think there's a number of factors that go along with that, such as the severity of the injuries, the current Medicare status of that individual, and certainly how far along these regulations move. So I'm not envious of the parties who have to settle these cases and navigate these questions for which they don't quite have answers to yet.
Yeah, I share your sentiments, Sean. I think it's case by case. I think you have to look at the Medicare beneficiary status. I agree with everything you just said. It's certainly case by case, and we consult with clients in that regard. Like, there's certain unique scenarios where, an LMSA might not be needed, or it might be some that are obviously, wow, yeah, because it's hard to set a bright line rule until Medicare formalizes any guidance around that. So we'll be looking for that and staying on top of that proposed rule. Let's shift gears a little bit and talk about this recent discussion in the work comp space on evidence-based Medicare set-aside. So for those of you that are not familiar, I'll tell you what an evidence-based Medicare set-aside is. They've become very popular in our industry probably since about 2014, 2015. We've started to see a lot more evidence-based Medicare set-asides. And so what they do is they leverage nationally accepted clinical guidelines such as ODG and ACOM, or if the state has a specific evidence-based guideline, allocating using that regimen. It contemplates treatment that is both, appropriate and reasonable, and accounts for anticipated decline in treatment over time. And when they're used properly, they do still protect Medicare's interest by fulfilling the future medical compliance obligations. It's defensible, it's reasonable, and it ensures you only pay what is reasonably expected. So now it's a different mindset from Medicare. And so I mentioned, I'm going to talk a little bit more about it later on, but Medicare recently hosted a webinar on MSAs just last month, and they made it clear that when they review an MSA, their mindset is worst case scenario methodology, right? Like, if there is any possibility the claimant's going to need a particular surgery, it's going in the MSA. If there's any possibility that the claimant might need a particular drug, it's going in the MSA over the expected lifetime. Whereas the objective with an EB MSA is more, let's look at these nationally accepted clinical guidelines, which aim to improve medical outcomes for Medicare beneficiaries, to give them a reasonable allocation that not only is defensible and sufficient, but also, like I said, will help the Medicare beneficiary with regard to improvements. I have personally seen, Sean, numerous CMS determinations where they have allocated opioids in particular with a drug regimen that, given the person's age and medical status and the amount that they've allocated, would literally kill the person in 6 months or less. And it's just, we're supposed to be cracking down on this overuse, but it seems like Medicare promotes it. Not that they want to promote it. It's more just like they're so afraid that they might have to pay for something in the future, so they're over allocating. And I think that's where, the frustrating parts come. What would you say, as far as your thought process on why the push and the recent, growth in interest in non-submits and EBMSAs over the last 10 years? Do you share a different view, or what are your thoughts there?
No, yeah, I think it primarily comes down to, if I had to guess based upon my experience, I think it comes down to cost. I think if all things were equal and there was a certainty around achieving a particular cost within the CMS submission process, I think folks would probably opt to submit, especially knowing that they go through the submission process. There's effectively a guarantee that CMS will be there to pay as primary payer should the account temporarily deplete or permanently exhaust. And you can't blame carriers and parties to a settlement for wanting to be cost conscious to go through a non-submit process. But I'd have to say it's primarily driven. I think it's driven primarily by cost. I think you do raise a really important point, though, Heather, with respect to CMS's methodology versus an alternative non-submit allocation methodology, and it is one of the concerns. If you take a current treatment regimen, a medication regimen at a specific dosage and frequency, and extrapolate that over someone's entire life, look, some people are really hurt and they need that type of medication regimen, but most folks typically don't. That's what the literature points to. And I think having that type of rigid methodology with the patient's, the individual beneficiary's safety in mind, plus the potential cost of having to fund that, should probably be reevaluated at this point. I will say kudos to CMS for highly recommending professional administration when frequently abused drugs, which are opioids and benzodiazepines, are involved. And recommending that professional administrators implement Part D drug utilization review guidelines and have drug management programs for the safety and efficacy of the treatment regimen that an individual goes through. It's very scary to think about someone getting $100,000 with opioids prescribed as a cash payer and have them go out into the retail pharmacy market and be like, good luck. It's for sure a concern. And I'll leave one more. Revision surgeries in the last year or two of a person's life. I struggle with those too. I know some people get them, but by and large, it's not likely someone's going to go under the knife to have a knee replacement in the last year of their life. So I think cost associated with the realistic probability of treatment have really pushed folks to want to look for alternative modes to protect Medicare's interests and effectively bypass the submission process.
Yeah, those are excellent points, Sean. And I do want to also highlight two other reasons why folks have opted for non-submits that I've discussed on the slide here. Number one being appeal rights. So I explained to you all earlier the limited re-review and amended review processes at CMS. So that's your only options for re-review if you feel that CMS issued an erroneous MSA or an incorrect MSA. In the instances that you don't submit, you're still preserving those later appeal rights should Medicare question the adequacy of the non-submit EBMSA. So that's another reason. And then another reason, and Medicare was quite open about this on their recent webinar, that they do abide by state law, but they're quite regimented about it. For example, like in Georgia, where non-catastrophic claims, employers are only required to pay treatment for a certain number of weeks. And Mr. Jenkins on the webinar recognized that statute, but he still said, even if you meet those requirements, we can't know you really truly meet those requirements. We're going to require you to go the extra step of getting an evidentiary court order stating that you don't meet any of the exceptions under the state law. So it's really, that's really a lot when you have a situation where you meet all the requirements under the state law and you have to go this extra step and spend extra money to get an evidentiary court order, which may or may not exist in certain work comp commissions. So I don't think CMS quite understands how the process works sometimes, unfortunately. And, moving forward, as Medicare mentioned very openly on their webinar, they assume worst case scenario when they review an MSA. And in all of these instances listed on the screen here, like the injured claimant has not returned for treatment in years, they're going to allocate accordingly, even if surgery is recommended, but the injured worker is not medically cleared to receive the surgery, they're still going to allocate for that surgery. These are all examples here of where Medicare assumes worst case scenario. Another reason why non-submits and EBMSAs have grown in popularity is that you avoid the turnaround times for CMS approval. Now, right now, it's not too bad. It's about 2 to 3 weeks, I think, given all documentation is submitted timely. However, that's 2 to 3 more weeks of having an open claim on your book. When you multiply that across all of your claims, that adds up, right? And, many MSA vendors, some have tailored back just recently, but my firm will still say that we will still back and we will indemnify the EBMSA should Medicare ever question it. We feel that confident in everything that we did with the MSA and that it protects Medicare's interests, and we will indemnify all parties to the settlement. And we truly believe they are legally defensible. And, all non-submit MSAs, even whether they use an actual evidence-based medicine in the methodology for allocating, they're all permissible under the current federal regulations. Medicare recently updated their reference guide in such a way which seemed to conflict with the regulations, which we'll talk about. But nonetheless, the one thing we need to know is that even the reference guide states there's no statutory or regulatory provisions requiring that you submit an MSA to CMS for review. If you choose to submit, then you have to comply with their policies and procedures. Namely, right now, if you have a 7-year-old MSA, you cannot get that re-reviewed at CMS. So it's something always to keep in mind. Another point about evidence-based medicine is that actually Medicare recognizes the use of evidence-based medicine. And they actually say this in their WCMSA reference guide, that the WCRC, their review contractor, that they rely on evidence-based guidelines for review of MSAs at CMS. But here's an example of where their policy actually conflicts with the practice, right? So Medicare knows that using evidence-based medicine is legit and it should be used in MSA, so they put it in their guide. But on the other hand, we don't actually see the WCRC using these guidelines because it conflicts with the worst case scenario possible, type methodology in allocating. But nonetheless, I think this gives us even more ammunition to say that evidence-based Medicare set-asides are defensible. And as mentioned multiple times, until Medicare removes, 42 CFR 411.46 D2, which allows parties to allocate a certain portion of the settlement for future medical, non-submit MSAs are defensible. And so even still, if Medicare, says, well, okay, we know that you did a non-submit MSA with your settlements, but we're still reserving the right to recover or to coordinate benefits up to the entire settlement amount. It sounds scary, but let's talk through that here. Let's talk, Sean, about this letter that's been going around. So I know a lot of people received this letter. A bunch of people called me and said, have you seen this letter? Have you seen this letter? And it really just made its way around. Interestingly, it's the only one I've seen. So I don't know if there's multiple or if others have received more of these, but this was a situation where CMS apparently got notice that a claim settled, a workers' compensation claim settled with a non-submit MSA. And they sent this letter to the Medicare beneficiary saying, hey, we're aware that you opted to not use our voluntary process and that you settled your claim with a non-submit MSA, but we can't know that you protected our interests automatically, and we have the right to deny benefits up to the entire settlement amount. But I think we all got a little more terrified by it than we should have, Sean, and I'm curious to know what you think, but first I'm going to give my perspective. And so as I mentioned, it's just CMS saying, hey, we know that you have a non-submit MSA. We have the right to question it later. The language comes off a little strong, like as if they're going to automatically assume that because you did not submit the MSA through their review process, that it's a burden shift to Medicare. And that's the unfortunate part of the way it's worded, because they cannot automatically assume it's a bad MSA. Furthermore, this letter really has no meaning until the injured individual actually exhausts their MSA and actually submits a bill to Medicare for treatment. And then here's one thing that a misunderstanding that I've been coming up against a lot, Sean. Again, please feel free to comment on this too when you comment next, is that people are starting to think that all of a sudden, if you have a non-submit MSA and Medicare becomes aware of it, that they're just going to assume it's a bad MSA. It's just CMS only opining on whether it's a bad MSA or not. No, there is an appeals process. So the way it would work, assume we have a Medicare beneficiary that exhausts their non-submit MSA and they submit a bill to Medicare for treatment that is related to the work comp injury. And for some reason, Medicare says, hey, I think, I want to look at that non-submit MSA and I want to look at how you spent it. Again, to our knowledge, Medicare's never questioned a non-submit MSA yet, but assuming this is how it would go. And the parties would be able to, and the Medicare beneficiary would be able to appeal that denial of benefits through the existing Medicare appeals process that exists today. Let's say it was a Sanderson firm non-submit MSA that we presented. We would assist that Medicare beneficiary in presenting evidence as to the sufficiency and the adequacy of the MSA, and the burden would be on CMS to prove that our MSA was not adequate in the first place. It's not an automatic rejection, and all of a sudden that the Medicare beneficiary is without recourse, and all of a sudden they're no longer going to have Medicare benefits. Like in an instance, if it was my firm's MSA, we'd be making sure that that treatment was covered. And I know that if the MSA was being administered by Amitros, you all would make sure it's covered. And you could also probably add in a little bit about how administration increases the longevity of the MSA, Sean. But where I'm going with this and what I want to drive home is that don't let CMS scare you. If you like non-submits, it's up to your risk tolerance. There are appeal rights, and we can defend the reasonableness of these EBMSAs. Sean?
Yeah, so there's a lot here, Heather, and you and I could probably do an entire 2-hour webinar just on this slide, and I'm cognizant I can be long-winded, so I will restrain myself. But a few thoughts, and I'll caveat by saying, or give this disclaimer. Ametros is agnostic towards how and respects how parties want to settle a case, regardless of my underlying either internal legal opinion. I'm agnostic towards it and respect how parties want to resolve their claims relative to future medical considerations. So that being said, I think you're right. Following issuance of a letter like this, there's really, however you want to interpret the letter, there's no practical effect until there is a denial of benefits, at which point it can trigger the appeals process. Just a thought that sort of occurred to me, should the sufficiency or adequacy of an MSA ever come under scrutiny, then there would be some sort of burden shift towards the party asserting that occurred. And I would imagine if a lot of work went into and thoughtfulness went into making a determination around that allocation, and if it had some semblance of reasonable treatment that this individual was going to require, there might not be a situation where it would unnecessarily or prematurely deplete or exhaust. And most, I think, and I can't speak for vendors. Ametros doesn't prepare allocations or do MSP work, but we would certainly professionally administer any allocation that came our way pursuant to CMS's guidelines. I think, and this is just sort of me hearkening back maybe 5 years ago, I think when this was more of the non-submit trend was something that was just starting to come into existence, I think there was probably more leeway given to a wholesale elimination of items and services. But I think if you're looking to adequately protect an individual and consider and allocate for what they're going to need, then there should be no premature exhaustion or depletion. I guess that's what I would say to that, if that makes sense, Heather.
Oh, it absolutely makes sense. So we're going to keep going because we got a little bit more to cover, and I want to save some time for questions. I already see a whole bunch of questions for us in the queue. So as I mentioned, these are not going to be automatically deemed a burden shift. There will be administrative appeal rights on these MSAs. Should Medicare ever actually question one of these non-submit MSAs, we'll see in the future. There's opportunities for appeal, and then certainly if the preparer of the MSA is going to back the MSA, they will defend that. Let's just talk a little bit more in detail about what spawned this conversation, right? Medicare updated their reference guide, their WCMSA reference guide in January of this year. And it's the first time where we've seen CMS address non-submit MSAs. And they issued this reference guide with this new section. It was section 4.3. And they had some strong language in here saying that an inadequate non-submit MSA is going to be deemed a burden shift. And then Medicare can deny payment for medical services to the Medicare beneficiary up to the entire net settlement amount. But it's interesting how when Medicare hosted their webinar a month later in February, they stepped back a great deal from that language and did recognize that evidence-based MSAs are not automatically deemed a burden shift to Medicare, and that reasonable allocations will still be considered protective of Medicare's interests. So unfortunately, The written guidance is very strong and contradictory and almost like a scare tactic into CMS submission. And then we've got the CMS webinar where Mr. Jenkins did back off this language a little bit here. But here's the text of the update in the reference guide. If you've not read it already, I encourage you to do so. It's, like I said, it's got some very strong language here. I know that after it came out, I don't believe that Medicare really thought they would receive so much inquiry or so many questions or so many parts about like, what does that mean and what does that mean? They definitely had a lot of the industry coming at them and talking to them. And so I think that's why they hosted this webinar on February 17, 2022, which not only addressed traditional MSAs, but it also addressed non-submit MSAs in their recent update. But they said, you know, you all probably want to know why we put this language in the new reference guide. And the reason is that they said they were asked by multiple parties in the industry for years about what their stance was on non-submit MSAs, and they felt compelled that they finally needed to put something out. But they did say this is not a new policy. This is not a new policy, and that nothing from a legal, regulatory, or policy standpoint has changed. And again, during the webinar, the verbal comments, you know, confirm that they can't automatically assume that a non-submit allocation represents a burden shift. Instead, they're going to determine and evaluate a non-submit allocation post-settlement and post-exhaustion to determine whether it was sufficiently funded. And John Jenkins, who led the webinar, he is in charge of the WCRC and works at CMS in the MSP policy division. He repeated several times throughout the webinar that submission of an MSA to CMS is voluntary. And one other question that came up on the webinar, you know, because of the new update, section 4.3, which, you know, folks saw as sort of a scare tactic into submitting to CMS, we're like, wow, now I'm having claimant attorneys all concerned. And even though our settlement doesn't even meet CMS review threshold, they want to try and submit and get this does not meet threshold letter from CMS. And CMS confirmed on the webinar that those settlements that are underneath threshold should not be submitted to CMS for review, and they will not issue a does not meet threshold letter. So in those instances where your threshold is not met, do not attempt to submit those to CMS. They did seem to indicate that there would be some kind of written clarification to this effect coming out on that, and we have not seen that yet, but we'll wait and see. But, you know, what are the long-term takeaways? So, and what I'm seeing, you know, from my practice and with our clients is that many employers and insurance carriers are continuing with non-submit MSAs. They know that they're reasonable. And then there are folks that are a little bit less risk tolerant and prefer the traditional MSAs. It's not my place to say. I'm kind of like Sean too. You know, you tell me what your risk tolerance is and what your goals and objectives are for your settlement. Traditional MSA submitted to CMS or a non-submit MSA, both are viable and are allowable under the law. So if you take away anything today, traditional MSA or non-submit EBMSA, they're both okay. And that kind of rhymes a little bit. So I'm going to give myself kudos on that one. So anyway, you know, as I mentioned earlier, let's keep an eye on this proposed rule that Medicare is working on as it relates to future medical, because it may impact work comp MSAs. But until then, nothing from a legal or regulatory standpoint has changed. And we are still in a place where we can do all sorts of things. Just briefly, if you're not familiar with my firm, we're, like, as I mentioned, we do all sorts of MSAs. We have a great clinical team, workers' comp, liability MSAs. We've got those indemnified EB MSAs. We have a compromise MSA for your fully denied claims. I want to talk to you all just briefly about a new product we have, our MSA intervention assessment, which is great for traditional MSAs so you can get a reasonable allocation approved at CMS. We help folks with conditional payments at all levels, from the contractor level and with Medicare Advantage plans all the way up to the ALJ level and QIC. We're helping folks getting their Section 111 in line this year because Medicare is looking to potentially issue penalties for non-compliant insurers potentially as early as this year. So we've been hearing a lot about, you know, folks wanting to get their reporting in compliance, and some additional services as noted on the screen. And lastly, so we've got some folks that definitely want to submit their MSAs to CMS, but you don't want to be in a place where Medicare can allocate in a worst case scenario possible manner, right? So what we will do, and we can do this pre or post MSA, is we're going to take a look at your medical records. Our clinical team is going to take a look, and we're going to identify some key cost drivers that we think would drive up your CMS determination. And we're going to make recommendations to you as to how to reduce those cost drivers now. And I give an example here on the screen of an actual example where we were able to, potentially reduce the MSA. This is a small number of a reduction, but on some greater MSAs where we can really identify some cost drivers that can be beneficial. So this would be attorney-client privileged with my firm. It would be between us, and that would give you a more reasonable allocation when you go to submit to CMS. So if you have interest in that, please let me know. Also, if you would like to submit a referral to Sanderson Firm, I've included our email address here on the screen, and you can email that email address anytime with any questions. Briefly, Sean, I want to tell everyone about Ametros. And again, I highly recommend Ametros. Anybody who asks me for a recommended professional administration vendor, I say, we recommend Ametros. I think you all do a great job with your program.
Yeah, thanks, Heather. And I guess first, before I do this, and I know we're going to go to questions, I want to thank you personally for having me as a guest here today on this presentation. Thank you and Sanderson Firm. I highly respect you, Heather, and have just been a fan for numerous years of the contributions you've made to the MSP industry and continue to make. So thank you so much.
Thank you.
So what do I have to say about Ametros? I really feel on a moral level that professional administration does something pretty amazing for people who've been in the throes of the workers' compensation system or going through a bodily injury claim for a long time. And we see it here at Ametros as a mission to help people who've had the support of a claims adjuster and their attorney and a nurse case manager and all that support that goes along with being in the claims process for years, sometimes decades, so that when they are faced with having to manage a post-settlement medical fund, whether it be an MSA or an LMSA or a submit or a non-submit, they have the resources there to ensure, first and foremost, they're going to be in compliance with CMS's guidelines around administration, and that they're going to have help and support. So there's continuity of care, no disruption with receiving medical payments and such. And I think there's also a safety issue, as I mentioned, when an individual is giving, I don't know what the average amount is. I think it's around $90,000, $100,000 of an MSA when they're, sent off into the world as a cash payer. And there's no safeguards with respect to oversight of their, especially their prescription drug utilization. There can be dangers there. And I think last thing I'll say about it too, it protects all parties involved. It protects the individuals who are going through a lot of work like yourself to allocate as accurately as possible what these folks are going to need. So there isn't an unanticipated exhaustion or depletion that occurs. And it protects the individual beneficiary's attorney too, who's trying to educate them on what options they have with settling a claim. And certainly it takes away that potential for the individual to want to go spend it on, something that we always say the proverbial boat, but they spend it on something with, connected to potentially mismanaging their funds. So we're just here to help injured people stay healthy and ensure that their funds are getting expended properly.
Great, thanks, Sean. We're going to take questions. I'm going to leave my email up on the screen, also our website. If you would subscribe to Sanderson Firm's blog, I'd be grateful. We do issue blogs as updates do arise in the MSP, and also that's where you'd find out about future webinars. So if you could contact and subscribe there, we'd greatly appreciate it. Let's take some questions. Okay, what do you recommend when CMS demands the last 2 years of medical treatment records, but the claimant is not treated in the last 2 years? How do you resolve this impasse? That's a very difficult one. My understanding is that in that situation, Medicare is not going to review a proposed MSA. They need some medical records to go off of. I think in some instances they have taken a certification from the attorney, the Medicare beneficiary's attorney, that there's been no treatment in quite some time, or the adjuster. But those are going to be situations where you're probably going to need to do a non-submit MSA. I actually talked to Medicare about this. They weren't aware of the stringent documentation requirements that are currently there, and these are situations where folks might want to submit an MSA to CMS, but just might not meet CMS's review parameters. And in those instances, non-submit MSAs are okay. Do you have any additional thoughts there, Sean?
No, I mean, I would say so. I'm just trying to maybe clarify the question a little bit. Let's say there hasn't been treatment in a year and a half. 1 year. There's been 1 year and 6 months of treatment. I would assume that the 1 year, 6 months of medical records and pay histories would suffice, and they wouldn't need to, try to conjure up 6 months of additional treatment. I think they're looking at the most recent 2 years of treatment, whatever's available. But to your point, yeah, maybe during the process of developing the case on CMS's end, they'll require some sort of certification if they see something is off with respect to the pay histories or something.
Perfect. After a liability case settles and the parties were forced to compromise, is it possible to reduce the MSA by these or any factors? Now, it's an excellent question. I know the last time Medicare started to move forward on liability MSAs, this was like one of the most prominent comments back to CMS is, how are you going to review LMSAs when most of these liability settlements are occurring to foreclose the claim and are settling with contested liability? So the answer to the question is it possible to reduce the MSA by the reduced settlement value? Yes. Do we have any framework that's approved by CMS in which to do so? No. But I think that the proposed rule that we're going to see from CMS should address this issue. If it's not, then we're just going to have to go with a reasonableness factor. And I think until Medicare comes out with a final rule or regulations on MSAs and liability MSAs, how they should be handled, I think that we can only do what's reasonable. And in cases where you have an apportioned settlement, then yeah, the MSA should be reduced. So that's an excellent question. Yeah, I had a question on the indemnified MSA and how it works at my firm. So our indemnified MSA, so we prepare an evidence-based Medicare set-aside. We look to the allocation guidelines adopted in that particular state. We apply the evidence-based methodology. At that point in time, our indemnification, should this ever become an issue, already extends to the employer carrier that is referred as the MSA. And then my firm would enter into indemnity agreements with any parties that would like to be protected. The exposure is obviously the delta between the MSA and the settlement amount, because the maximum Medicare can recover is the settlement amount. We've already apportioned the MSA, right? So be really careful if you're looking at indemnified MSA programs at different companies, what they're actually indemnifying you for. Are they actually indemnifying just the MSA or the real exposure, which is the delta between the MSA and the settlement amount? Also, look to see if they're agreeing to indemnify all parties to the settlement. There is exposure on the claimant side if the Medicare beneficiary is denied benefits. And, arguably, if the non-submit MSA does not protect the Medicare beneficiary and their attorney, then it's not a good indemnification. We'll indemnify all parties to the settlement. So I don't want to make this a sales pitch. So I'm going to reach out to this person directly with more information. And if you also have questions on our MSA offering, please let me know. So we've got another one here. Oh, these are questions. I'm sorry. Who holds on to the liability Medicare set aside is a question. That would be the Medicare beneficiary, just like it would be in workers' compensation. The Medicare beneficiary in a liability case that receives an LMSA, arguably, right, Sean, would have to do the same things. Put it aside in a separate interest-bearing checking account, or have a professional administrator such as Ametros administer the funds, but the money is not staying with the insurance carrier or the liability self-insured.
Correct. Hopefully it would be the latter. Hopefully they would choose to have it professionally administered by Ametros. But yeah, the concept would would be the same. That's a decision point either at